On Tuesday, April 30th, the Karen Read murder trial continued with more testimony in the Commonwealth of Massachusetts case in chief. On day 2, we heard from 4 witnesses. 2 of them were Canton Police Department officers who arrived on scene where John O'Keefe's body was found the morning of January 29th, 2022. And the other 2 were firefighter paramedics who arrived to try to administer patient care and take life-saving measures. And at the end of the day, I walked away thoroughly impressed by the defense team and unfortunately quite disappointed by the prosecution. And what was the biggest highlight of the day? Some absolutely masterful cross-examinations, particularly by defense attorney Alan Jackson. And what they brought out was 2 very important things. That was problems with bookkeeping by the police that show, at the very least, an incompetent investigation by the police, and at worst, outright lies and cover-ups. And second, memory issues with the key witness testifying to hearing Karen Read make damning admissions. Let's get into it because I really want to know what you think. So before we get into the details, let me first remind you that the 2 sides of this trial have different goals and different ways to win. The Commonwealth, also known as the prosecution, has one path to win this case, and that is proving beyond reasonable doubt that Karen Read murdered John O'Keefe. The prosecution is the side with all of the burden, so it's up to them to prove this case. The defense, on the other hand, has no burden, and that means that the defense actually can win in either of 2 ways. First, they can either poke enough holes in the prosecution's case to draw out reasonable doubt as to whether or not Karen killed John. Or second, they can convince the jury that Karen Read is in fact a victim of a conspiracy by the police to frame her for someone else's wrongdoing. To be clear, to end up siding with the defense, it's not required that you go so far as to say that she was in fact framed. You can conclude that you don't believe that she was framed, but still decide that there's enough reasonable doubt in this case by the end of this trial to say that the prosecution hasn't met their burden and that the jury should not convict Karen Read. Both of those things can be true at the same time. And that ties into why at this point I'm both disappointed in the prosecution so far and very impressed with the defense at this point. When you're the one with the burden, you've got to show up from the beginning and do the work to meet that burden by convincing the jury every single day. And instead, the prosecution, in my opinion, is putting on a lackluster case. And look, I don't mean to gang up on Assistant DA Adam Lally, but there's nothing in his overall presentation, vocally, body language-wise, that tells me that he believes in his case. During all of his direct examinations, he actually sounds kind of bored. He's prone to heavy sighs in the middle of a question that seem to suggest he doesn't actually want to be there.
Now, so you arrive there, you see Officer Sarafin and people from the fire department, correct? And you mentioned sort of a mechanical means of CPR. Is there a specific device that's used for that?
And in fact, I don't get the sense that he wakes up each morning of this trial with any passion or excitement thinking, today is another opportunity to seek justice for John O'Keefe, the victim in this case. And look, the jury might not notice this in the same way that my neurodivergent brain does, but he uses some version of what, if any, so often in his questions that it becomes an outright distraction. Sometimes it's what, if any, sometimes it's who, if any, or where, if any, or what, if anything.
What, if anything, did you note at that time or at any subsequent time in regard to footwear? What, if anything, happens with that? What, if anything, did you observe? What, if any, involvement did you have with that? What, if anything? What, if anything?
And if you watched the Depp v. Heard trial in 2022, you're probably familiar with this phrase as a strategy to get around an objection that you're leading the witness on direct examination.
What, if anything, had been said about what Mr. Depp did the night before?
Objection to the extent it calls for hearsay, Your Honor.
All right, be a hearsay objection. I'll sustain that objection.
I'm asking what, if anything?
That was still solicit hearsay.
To me, this use comes from a misunderstanding as to what it means to lead a witness, which is basically asking a question that already suggests the answer in it. And here, as was the case with attorney Elaine Bredehoft and Depp v. Heard, I just think that this is an advocacy crutch that ADA Adam Lally has developed over the years into a habit that's just part of his speaking pattern at this point. But the problem is, it's personally driving me nuts already, to the extent that I've actually started keeping a tally as to how many times Adam Lally uses some version of what, if any, in his questions. On day 1, he used it 101 times. And on day 2, a half court day in which there was a lot of cross-examination by the defense, he said it 66 times. So we are up to a grand total of 167 what, if any's in this trial already at the end of day 2. In my opinion, that's a lot. And the thing is, all of that makes it harder to pay attention to what exactly he's asking and what his witnesses are actually testifying to. And on top of that, Adam Lally also has a tendency to ask a lot of detailed questions, focusing on things that actually don't matter to either the prosecution or the defense. And look, typically you do need to get into some foundational matters so that, witnesses can be introduced, for example, and we can trust that what they're saying is true and accurate. For example, getting the credentials and a little bit of history from paramedics is important so that we can trust that what they're testifying to regarding the victim's injuries and what they did to treat them is the kind of thing that we can actually rely on because they kind of know what they're talking about. But the problem is, Adam Lally gets lost in the weeds with these witnesses at the beginning of every direct examination. As an example, he has asked every single first responder so far for the exact route that they took to get to the crime scene from wherever they were coming from. We don't need to know this information. There's no dispute about how long it took anyone to arrive and respond to the 911 call, for example. So every time he asks for the exact route that they took, a right on this street, a left on that street, I can't help but think about Saturday Night Live's recurring sketches, The Californians.
I know a shortcut through El Segundo. Take the 105 West and exit on Cabo. When you see the Zanko chicken on the left, turn right. Take Venice and follow it all the way down. Then you're in Marina del Rey.
And it's kind of funny to talk about, but in reality, it's a problem for the prosecution because I'm an attorney and I'm interested in this case. Unlike the jury, I'm not forced to be here watching this trial. So if my mind is getting sent off to think about other things, the same can definitely be true of the jurors as well. And this is now leading into a bigger problem for the prosecution overall as it relates to the attention of the jury. Because keep in mind that jurors may or may not have experience being on a jury panel prior to this trial. They might not be familiar with the legal process in general. In fact, it's actually probably most likely that they draw more than anything from movies and TV shows as a basis for understanding what a trial is supposed to be like.
In an investigation, details matter.
So all of that basically means that in the early days of a trial, the attorneys on both sides are kind of training the jury as to what the jury can expect from either side moving forward. A big part of this, of course, is in opening statements, as I talked about in the day 1 recap. But that training doesn't end there. It continues throughout trial and is especially established in the early days. And my concern for the prosecution at this point is that they're training the jury that whatever it is a witness is talking about at the beginning of their testimony, the jury is free to check out. The details that they're going over in the testimony don't really matter for the first 5, 10, 15 minutes, sometimes more. And keep in mind, jurors are not robots. Their brains, just like anybody else, don't have an unlimited capacity for attention. So it's natural for people to start to calculate, whether consciously or subconsciously, when they can save those mental calories or when it's going to be worthwhile for them to actually invest that attentional energy into the testimony that's unfolding in front of them. And establishing that trend to lose the jury right off the bat in the beginning of every witness's testimony also leads to another problem. How does the attorney get the jury's attention back to the testimony when they're going over details that really do matter to this trial? As I often say on this channel, the jury's attention is absolutely crucial and often means the difference between winning and losing. It's like the saying, if a tree falls in the forest and there's no one there to hear it, does it really make a sound? For trials, it's if the most important evidence comes out at trial, but the jury's asleep, was it ever really presented? If the prosecution introduces something that is absolutely crucial to proving their case beyond reasonable doubt, but the jury is off counting the panels in the ceiling, it's not going to help the prosecution win this case. Anyway, I'll step off my soapbox on that one, and let's turn to the substantive testimony that actually came out on day 2. If you saw the day 1 testimony or our day 1 recap, you know that at the end of the day, the prosecution finished the direct examination of Officer Steve Saraf. And one of the most important things that came out in his testimony was that he said that he heard Karen Read say something along the lines of, "It's my fault, I hit him." Now, on day 2, we got to see the defense cross-examine a witness for the first time, and I was really looking forward to see how they would go about it. And I have to say, defense attorney Alan Jackson did not disappoint. In fact, he gave everyone 2 master classes on how to run a textbook cross-examination. We'll talk about both of them in a bit of detail in this recap. First, let's pick up with Officer Saraf's cross-examination, since that was the first one of the day. Now, right off the bat, I knew that this cross-examination was going to be absolute fireworks because Jackson's very first question was this.
Good morning, Officer Saraf. Good morning. Is there anything that you would like to change or amend or modify about your testimony yesterday that you thought about overnight?
No.
Now, this is a shot across the bow, a loud warning that he has found something in the witness's direct examination that is inconsistent with some other evidence, maybe the witness's own statement. And what followed that shot across the bow was a methodical progression where Alan Jackson revealed the witness first to be someone who looked like he did an incredibly incompetent job as a police officer at a crime scene. And then by the end of the cross-examination, brought out testimony that made it appear that not only was Officer Saraf incompetent with this case, but also dishonest, maybe even crooked. And remember how I just said that in the early days especially, the 2 legal teams are creating and setting expectations for the jury. And the prosecution has started to establish this trend that the jury doesn't really need to pay attention to the beginning of a witness's testimony because nothing interesting happens then. Well, the defense on day 2 has established the exact opposite trend. Their lines of questioning show that if you are not paying attention to the beginning of their cross-examination of these witnesses, you are going to miss something important. And the very first thing that Alan Jackson got out of Officer Saraf was that the Canton Police Department messed up some basic routine aspects of this investigation from the start and in ways that are totally egregious. Now, do you remember how in the day 1 recap, I said that the opening statements are essentially a series of promises by that side, that they're going to show the jury evidence that supports their arguments and that therefore they should end up winning? And do you remember how I also said that at the end of the trial, the jury is going to determine whether or not that side kept those promises? Well, in opening statements, the defense made promises to the jury that they would ultimately conclude that they couldn't trust the investigation by the police in this case. And that's because it allegedly had metaphorical fingerprints all over it belonging to someone who had every interest in framing Karen Read and covering for someone else. Those are huge promises and make for a great opening statement. But the big question is, does the evidence actually back it up? And in this very first cross-examination by the defense, they showed the jury immediately that they were making good on these promises. First, Jackson went through the dispatch log. This is such a routine document that basically just shows when a 911 call was made, which officers responded to it, where they went, and when. It's so routine that it often gets basically ignored as a boring document that no one really cares about unless there's some kind of a dispute as to when the police responded to the 911 call. But here, Jackson pointed out masterfully some egregious issues with the accuracy of this document, namely which officers arrived in what order and at what times.
So all 3 of you, according to the official document generated by Canton Police Department for this event, has Officer Mullaney arriving first, you arriving second, Sergeant Good arriving third, all within 7 seconds of each other, correct?
Correct.
That is completely false, isn't it?
Yes.
Yeah, you've looked at your dispatch, your dash cam, correct? And clearly, we saw it yesterday. You arrive and there's nobody else on scene.
Correct.
That was at about 6:10 a.m. that you arrived, correct?
About that, yes.
And then Officer Mullaney actually arrives after you about 6:11 a.m. Is that right?
Yes.
And Sergeant Good does not arrive, according to your own dash cam, until about 6:16, a little after 6:15.
Yep.
All right. So right off the bat, the official Canton Police Department dispatch log, one of the first documents generated in any investigative event, that's completely wrong, right?
The times are, yes.
Well, the times and the orders,
Mhm.
right? I mean, not only did Officer Mulaney not arrive first, you arrived first.
That's
And
correct.
then he arrived.
Sure,
So that's two things that are wrong about just that, correct?
sure.
And then it has Sergeant Good arriving 4 seconds after you, which is also incorrect.
Yep,
He didn't arrive until about 6 or 7 minutes after you, right?
sure.
All right.
So already at this very, very early stage, the defense has shown the jury that they can't trust basic routine documents put together by the police in this investigation. Now, does it look like corruption and conspiracy? I don't know about that. But it certainly looks like incompetence, and that's enough, in my opinion, to start really opening some big doors to reasonable doubt. But wait, there's more. Trust me, this is just the beginning of this cross-examination. After Jackson established that the dispatch log has these times and orders completely messed up, he asked Officer Saraf if, other than that, the document was accurate. And Officer Saraf answered, yeah, everything looks right.
Is the dispatch log otherwise accurate?
Yes.
But then Jackson pointed to another issue with the dispatch log, this time related to the address that John O'Keefe was found at, 34 Fairview Road.
It says 32 Fairview.
Did you arrive to 32 Fairview Road?
No.
You arrived to 34 Fairview Road,
That's correct. Yep.
So that even the location on the dispatch log is faulty, is that right?
Sure, yep.
And then the defense pointed out that it's not just in the dispatch log that Officer Saraf got the address wrong. He also testified under penalty of perjury to the grand jury that he arrived at 35 Fairview Road, not 34 Fairview Road.
Where did you indicate to the grand jurors that you actually arrived?
It says 35 Fairview.
I know what it says. I'm asking if it refreshes your recollection that you actually testified under oath that you responded to 35 Fairview Road.
Yes.
And that is incorrect as well, isn't it?
Yes.
Then he brought up Sergeant Good's report, and I'm sure we'll hear from Sergeant Good soon, which included what Officer Saraf reported about that address.
Are you aware that have you ever discussed with Sergeant Good that he wrote in his official report that you responded to 32 Fairview Road?
No.
And of course, we just talked about the fact that the dispatch log lists 32 Fairview Road and not 34 Fairview Road, correct?
Correct.
So none of the initial police reports, not the dispatch log, not your police report, apparently not Sergeant Good's, list 34 Fairview Road as the actual location where you responded that morning, correct?
As far as I know, yes. Yes, sir.
Was there an effort on your part or anybody else's, to your knowledge, to mask the actual address of Brian Albert's house as 34 Fairview Road?
No. No.
All those were just mistakes,
Yes.
over and over and over.
Yes.
So many issues here. Okay, so then Alan Jackson shifts gears and turns his focus on the statements that Officer Saraf said Karen Reed made. Remember, on direct examination, he said that she made statements amounting to basically, "It's my fault, I hit him." So Jackson brings in the incident report that Officer Saraf made later that day on January 29th, 2022. And the defense pointed out that in this report, Officer Saraf did in fact make a note of a statement that Karen Reed made at the scene. But it wasn't, "It's my fault, I hit him."
And the only statement you attribute to my client on that morning, just hours after the incident or minutes after the incident, was she kept repeating, "Is he dead?" Right?
Yes.
So then Jackson brings up how the next day, Officer Saraf was interviewed by Trooper Michael Proctor, the leading investigator who got a lot of special mention in the defense's opening statement. And Jackson pointed out that in this interview, he confirmed again, Karen Reed exclusively shouted over and over again, "Is he dead? Is he dead?" So here we can see that in the early days, Officer Saraf's statement about the statements that Karen Reed made at the scene were consistent. Is he dead?
You told Trooper Proctor that you could, quote, hear Karen Reed continually state, "Is he dead?" as the paramedics treated the victim. Officer Saraf then seen Karen inside her friend's vehicle, correct?
Correct.
In the 2 times that you were asked to reflect back on exactly what happened that morning, on January 29th and January 30th. Both times, you attributed only 3 words to my client having been repeated continually in her distraught state. Is he dead? Right?
Yes.
And she wasn't saying that calmly, I'm assuming.
No.
Matter of fact, you used the word she was severely distraught. Is that right?
That's correct.
But remember, in direct examination on day 1, Officer Saraf said something totally different. So Jackson then turns to several months later in April 2022 when Officer Saraf testified at that grand jury hearing. And as it turns out, at that grand jury hearing, Officer Saraf testified differently about what Karen Read's statements were than what was represented in those early reports.
On April 14th, 2022, months after this event, for the first time, you said, quote, and these are your words, tell me if I get them right. She, this is my fault. I don't know. She said, I can't believe this happened. I mean, she kept asking if he was going to die, if he's dead. And, I just basically said, we're doing the best that we could, end quote.
That's correct.
So in April of 2022, for the first time, you attributed the phrase, "This is my fault. I can't believe this happened," to my client, correct?
That's correct.
But nowhere in your official report did you say that.
That's correct.
And nowhere in your interview with Trooper Proctor the next day did you say that.
That's correct.
You think that was a pretty important omission on your part?
It was an oversight.
An oversight.
Yes, sir.
That a woman whom you made contact with, standing over the body of a fallen police officer, said to you, "This is my fault." Just missed that one. Yes?
Yes, I missed it. Yeah, I didn't write it down.
And then, of course, you testified yesterday and your statement changed again, right?
I don't.
Now, later in the cross-examination, Jackson actually also circled back to this topic to get from Officer Saraf that he never heard Karen Read say at the scene, "I hit him."
At any point when you were at that location, did you hear my client repeating the phrase, "I hit him, I hit him, I hit him, I hit him"?
She said, I hit him? No, I didn't hear that part.
And then this is kind of a side note, maybe a nothing burger, but remember how earlier in this video I said that for most people, the things that they know and understand about the legal system are usually things that they see in movies and TV shows. Well, earlier this year, I know that a bunch of people were talking about the TV show Reacher when it came out with the second season. Maybe it's just on my personal radar because I saw it for the first time around them, and Mr. Bites and I got pretty hooked, even though I kept calling out all kinds of criminal activity by the protagonist of the show, but whatever. Let's just say that there were a few issues that should have gotten Reacher convicted of several crimes. Anyway, that's not the point. The point is, I already mentioned it earlier in this video, but there's a line that Reacher would repeat throughout season 1 of the show, which is this.
In an investigation, details matter. Details matter. Keep telling you, Finley.
I know details matter. Let's go.
And I couldn't help but notice that Alan Jackson, at a couple points in the cross-examination, made what seemed like a reference to this.
You agree, we've already agreed, that details matter in any investigation.
Absolutely.
They certainly matter in this investigation, correct?
Yes, sir.
Now, maybe it's just a happy coincidence. Or maybe during jury selection, the defense team detected a likelihood that some of the jurors may be fans of the show. If that's the case, those jurors would recognize that line immediately like I did and maybe attribute some significance to its use, but definitely perk up in attention to this issue in the case that details are important and can make or break any investigation. Either way, I think it could help the defense here. Now, before he closed out his cross-examination, Jackson brought Officer Saraf's attention to Jennifer McCabe while she was at the scene. Jennifer McCabe was one of 3 women the first responders found at the scene. The other 2 were Karen Reed, of course, and a woman by the name of Carrie Roberts. Now here, the defense started to introduce questions about the conduct of other people around Karen Reed, and this is going towards that framing theory. Using Officer Seraf's and Officer Good's dash cam footage, Jackson highlighted the fact that Jennifer McCabe went into the house at 34 Fairview Road at some point. And he highlighted the fact that no one, including Officer Seraf, stopped her.
Officer Seraph, when you go to a crime scene,
Yes, sir.
one of the first things that you'd want to do is secure the scene and separate witnesses so that interviews could be conducted, correct?
Sure.
You wouldn't want witnesses just cavorting together and getting their story straight, right?
Correct.
You'd want to avoid that at all costs,
Yes.
right?
Yes.
And why is that?
So they can't collaborate their story.
Yet there was a person walking from the area where a body was found in the lawn of a house, walking into the house to make contact with other individuals, correct?
It appeared that way, yes, sir.
Does that seem appropriate to you?
No.
Of course not.
So again, this feels like maybe incompetence, maybe a cover-up, something along those lines. Either way, not good for the prosecution. Anyway, before closing out this cross-examination, ultimately, Jackson brought up the pieces of Karen Reed's taillight that the prosecution says the investigators found much later after some of the snow had melted. And he also drew out from Officer Seraf some other weird details that on their face, in my opinion, can't be explained by what we've heard about the prosecution's theory so far.
You didn't just stay in your cruiser. At points, you got out of your cruiser, walked over, made contact with the women, and you were standing next to the body.
Yes.
And you were obviously looking around. You noticed some footprints,
Yes.
and you even noticed some lack of footprints.
That's correct.
So you were being observant of the area of the body
Yes.
and the area adjacent to the body.
Yes.
You were looking for anything that might have been out of place,
Yes.
anything of any evidentiary value, correct?
Yes.
You never saw or otherwise observed or located a single piece of taillight material, did you?
No.
You certainly didn't see 45 pieces of broken plastic or taillight material, did you?
No.
You never located or otherwise observed John O'Keefe's missing shoe
No.
or any other clothing of his.
I didn't. No.
Officer Seraf, did you ever think to look inside the house for
No.
that missing shoe?
No.
That never crossed your mind?
No.
You think that might have been a smart thing to do at the time?
Objection, Your Honor.
Rephrase the question.
Sure. Do you think that would have been appropriate protocol when dealing with a body laying on a lawn that is partially unclothed to look inside the house of the lawn?
No.
You didn't think that would have been an appropriate protocol
No.
for you or anybody else?
No.
Obviously, you did not conduct a search of that house, did you?
Nope.
And you're aware that to this day, no law enforcement officer ever conducted a search of that house.
I'm not aware of that.
I have to say, the shoe thing is weird. I can't get that one out of my head. Okay, but anyway, that is Officer Seraf. The next witness to testify was Officer Stephen Mullaney, also from the Canton PD. I'll say up front that most of his testimony was fairly unremarkable, and there was a lot that he didn't seem to be able to remember on direct examination especially. However, he did testify to seeing Karen Reed, Jennifer McCabe, and Carrie Roberts at the crime scene when he arrived. He also testified similarly to Officer Seraf when he said that there was about 6 inches of snow under John O'Keefe's body. But he said that there was no snow on top of his body. Now, I know that some people have pointed out the fact that when both of these officers arrived, Karen Reed had been trying to perform CPR on John. And so that can explain why there would be no snow or only some snow on top of his body. However, it's important to note that in neither direct examination did Adam Lally highlight that for the jury. So if that's a point that he wants the jury to be thinking about, he's not doing a great job of connecting those dots throughout trial. Anyway, Officer Mullaney also testified to hearing Karen Reed screaming out repeatedly, Is that my boyfriend? Is he dead? There were no other statements that he said that he heard her make at the crime scene. And on cross-examination, defense attorney David Yannetti highlighted this point again. As it turns out, Karen Reed actually screamed this out over 10 times while at the scene. And Officer Mullaney also confirmed that he never heard her say, "It's my fault," or "I hit him." He also testified that although he was trying to observe the crime scene, he saw no pieces of taillight on the ground around John's body. Okay, so after Officer Mullaney, the Commonwealth called to the stand Timothy Nuttall. He's a firefighter paramedic with the Canton Fire Department. And on the morning of January 29th, 2022, he was just starting a 24-hour shift when he and other paramedics responded to a 911 call about John O'Keefe's body. He testified about John's injuries when they were able to examine him, although he said he couldn't remember seeing all the injuries that were brought up throughout his testimony. Overall, this witness seemed to me to come across as sincere and earnest in his testimony. At no point did he seem like someone who was trying to obfuscate the truth in any way. However, his cross-examination, again by Alan Jackson, was the other highlight of the day, where the witness's testimony became more of an issue because of his memory. And the reason why this is so harmful to the prosecution is because Mr. Nuttall appears to be the prime witness who says he heard Karen Reed say at the crime scene, "I hit him, I hit him." If Karen Reed did in fact make that statement, say those things, that's an admission by her, and admissions can and often do sink a defendant's case. But here's the issue. Another thing that he testified to was that John O'Keefe was dressed for the cold weather with several layers on. And this is something that he arguably would and should have noticed because the paramedics who arrived on scene, to include Mr. Nuttall, had to remove John's clothing in the back of the ambulance so that they could examine his injuries and try to give him life-saving treatment. And he talked about how parts of this process were difficult because of the fact that John was so cold that his hands and arms were a bit rigid. He didn't remember John missing a shoe, however. Man, I don't know why, but that missing shoe just sticks out to me for some reason. Like, how does a single shoe go missing after a hit and run? It's not like someone took a shoe, because why would they take one shoe and not two? And it needs some extra explanation if in fact he died by Karen's car hitting him. Like, what would have happened to that shoe? Anyway, the issue with his memory and the clothing that John was wearing is what came up on cross-examination. At one point, the defense asked Mr. Nuttall about the clothing, and the witness confirmed again that he remembered seeing that John had a big jacket on. And he seemed pretty confident in that.
I guess what I'm asking is, your attention is focused on some of those details for sure.
Correct.
All right. And that's how you remember that big heavy coat that he was wearing, correct?
I remember he was appropriately dressed, correct.
Okay. As a matter of fact, you testified to that in the grand jury, that, quote unquote, he had a heavy coat on.
Yes.
Consistent with how you're testifying today. Is that right?
Correct.
All right.
But then Jackson approached with a paper that had apparently a picture of the clothes that John was wearing that day. We didn't get to see it, presumably because it's not an exhibit that's been admitted into evidence yet. However, here's what was revealed in court about that photo.
You do recognize them?
Yes.
Does that appear to be what John O'Keefe was wearing when you found him?
I don't recall, sir, to be perfectly honest.
May I approach you?
Yes.
Do you recall this being part of, let me ask it a different way. Do you remember somebody cutting this off of John O'Keefe at the time?
I remember the clothing being removed.
Okay, but you don't remember this clothing?
I could say that he had clothing removed, but I couldn't tell you exactly what it was. You?
That appeared to be a thin cotton hoodie.
Yeah, that appears to be a thinner layer of clothing.
Okay, not a heavy coat. Is that fair?
Fair.
Not a winter jacket.
Fair.
So, as it turns out, Mr. Nuttall was convinced that John was wearing a big heavy jacket and that he was appropriately dressed for winter. But in actuality, John apparently wasn't appropriately dressed for the weather. He had on a thin cotton hoodie. And this is not to knock Mr. Nuttall as a person or as a professional. This is just a memory issue. All of us forget things from time to time, even when those things can be important to all of us. But the thing is, the jury has to evaluate each and every witness on a number of things, and that includes the ability to perceive when the events were happening, for any motives or interests they may have to testify in a particular direction, maybe, and for their ability to accurately recall those events later. And this cross-examination goes after Mr. Nuttall's memory in such a textbook kind of way. Jackson manages to avoid making it look like he's undermining Mr. Nuttall as a person or as a professional. And he even said at one point, "My point is not to cast aspersions on you. It's just a memory problem." Anyway, during the cross-examination, Jackson also turned his focus to the "I hit him" statements that Mr. Nuttall testified to. And here again, Jackson points out an inconsistency in Mr. Nuttall's memory about the exchange.
You claim to have heard this statement, I hit him,
Yes.
several times from the woman with blood on her face.
Correct.
You indicated that she was erratic,
Correct.
hysterical.
Correct.
You said, for lack of a better term, running around in circles.
Yes.
She seemed despondent or distraught,
Very distraught.
very upset.
Yes.
Was she saying anything else that you recall?
To me, I heard I hit him, and then I went back, obviously continuing on patient care, focusing on patient care.
Did you hear her say, could I have hit him?
I heard I hit him.
That's what you believe at this point.
That's what I heard.
Do you
Okay.
recall telling Trooper Proctor specifically that while you were rendering aid, you heard Karen say, I hit him, to another female on the scene, and the other female told Karen to be quiet?
I do recall that.
Okay. That's not what you testified to today, though.
Okay.
Matter of fact, that story has changed to you posed a question, and she answered your question. Correct?
Correct.
And the thing is, this inconsistency doesn't appear to be as dramatic or drastic as the statement inconsistencies that we saw from Officer Seraph. As far as Mr. Nuttall's statements go, one statement is not a completely different statement than the other. However, the fact that he is inconsistent as to whether he was the one talking to Karen Read or someone else was the one talking to her indicates a memory issue. And Jackson was able to actually increase the significance of this particular issue by managing to tie it back to the issue with the big heavy jacket, which was something that Mr. Nuttall had already agreed that was a mistake on his part.
And nobody's casting aspersions. Yeah. Memory's a funny thing. So your memory is as good about that as it is about that winter coat.
Yes, sir.
And that's where it landed. This was another absolutely masterful surgical cross-examination by the defense with no wasted time in the testimony. But anyway, there was one more witness for the day. This was Anthony Flamati, another firefighter paramedic who responded to the 911 call along with Timothy Nuttall. I'll be honest with you, I don't have much from his direct examination so far to give you as far as a recap is concerned. And that's because Adam Lally did not finish his direct examination on day 2. And despite the fact that Mr. Flamati had been on the witness stand for about 20 minutes, the prosecution didn't actually get to anything that was particularly relevant or interesting or important before Judge Canoni closed it out for the day. They had spent a lot of time on Mr. Flamati's background and credentials, and then a bit about earlier in his shift and his exact route to get to the crime scene, of course. I'm really not exaggerating when I say that the prosecution is creating a habit for the jury not to pay attention to the beginning of their direct examinations. But anyway, that's about what I've got for day 2. Speaking of setting expectations, I do realize that these first 2 recaps have been long ones, and especially with all of the clips that I've been using. Moving forward, I'm going to try to condense these a bit more just that I don't get burned out between streaming the trial and putting these recaps together. So although I love using the clips in these recaps, I'm not sure how many more times I'm going to be using them. I don't know. We'll see. But at any rate, the cross-examinations were, in my opinion, so worth going over because of just how beautiful the lawyering is coming from the defense in this case, and because of how important the pieces of information are that are coming from these cross-examinations. At this point, my opinion hasn't changed from the end of day one in that I think that the defense really has the advantage in this case so far. I really haven't seen anything from the prosecution that has stuck out to me as a huge problem for Karen Read. At least every time it seems like the prosecution lays some kind of groundwork down, the defense manages to pick it up immediately and reset it according to their own specifications. It really has been a wild thing to see so far. But those are my thoughts. What do you think? Have you been following this case so far? Do you have a way in which you might be leaning in terms of guilt or non-guilt? Or do you think that you still need some more information in order to make that kind of a determination as to having any kind of a leaning? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more recaps and live streaming coverage of this trial, be sure to hit the subscribe button and the notification bell so you can find out when the next recap or when the next live stream is up for you. See you in the next one.